Well, we're back for a third installment of our discussions with Edwin Smith about the 2022 amendments to the Uniform Commercial Code. And of course, he's our expert on this because he truly is. That's because he chaired the drafting committee for these 2022 amendments to the UCC in the organization Uniform Law Commission. So welcome back, Ed. And we'll just jump right in here. Last time, or the first time we talked, it was about an overview of the amendments. And then we talked about the new Article 12 on controllable electronic records. And so let's just jump into this question. In my practice, the part of the UCC that gets the most use is Article 9 on secured transactions. Could you give an explanation here on how Article 9 and Article 12 fit together?
Well, Tom, it's great to be back. And yes, it's nice to continue because we left off with Article 12 and now we've got to deal with what the spillover effect is into Article 9. And I'm sure that a number of people out there are wondering, gee, do I need to play around now with my forms? And the answer is generally no, that a controllable electronic record is still a general intangible under Article 9. A controllable account is still an account. A controllable payment intangible is still a payment intangible. So when your security agreements and your financing statements use those broader terms, they pick up the narrower terms that were devised in Article 12. And the normal attachment rules apply. You still need to give value. The debtor still needs to have rights in the collateral. And as a general matter, you need to have a security agreement signed by the debtor that reasonably describes the collateral. And you can still perfect by filing. There's no problem with perfecting a security interest in a controllable electronic record or a controllable account or controllable payment intangible by filing, but now there is an additional method of perfection, and that is control. If you have control as defined under Article 12, as we talked about last time, you can also, as a secured party, perfect your security interest. So this means that a secured party who has received, let's say, virtual currency in the secured party's wallet now has control, and that constitutes perfection, and there's no need to file a financing statement. And as an added bonus, the control priority beats the filed priority. So if SP1 takes a security interest in a controllable electronic record and perfects by filing, and SP2 comes along later and perfects by control, SP2 has priority even though it's later in time. And then the choice of law rules really follow to a large extent what we see in Article 12, except when you're perfecting by filing, you go by the normal rules of filing where the debtor is located. So that's how we spill over into Article 9, Don, and we think that will be a big step forward for perfecting security interests and obtaining priority in controllable electronic records.
Well, thank you. So another subject, my understanding is that a couple of countries have adopted Bitcoin as official currency in those countries. Is that true? And how does that affect, has that affected the 2022 amendments?
Yeah, and I think we may have mentioned this in our first session as well, Don, that El Salvador and the Central African Republic both adopted Bitcoin as fiat currencies in those countries. And when they did that, there's a pretty darn good argument that Bitcoin now becomes money under the UCC because the definition of money picks up any medium of exchange adopted by a government, and there's no distinction as between a domestic and a foreign government. And that really then spills through the entire UCC whenever there's a discussion of money, like a promissory note being payable in money. It could be payable in Bitcoin. Anytime there's a monetary obligation, an obligation to tender Bitcoin would be money. But most cruelly of all, if you want to take a security interest in Bitcoin and you're not going to opt into the Article 8 system and treat Bitcoin as investment property, the only way you can perfect is by possession, and you can't possess an intangible. So what we did with the 2022 amendments is we revised the definition of money so that if a country adopts a medium of exchange that already exists as its fiat currency, that is not money. So that would exclude Bitcoin, that would exclude Ethereum, it would exclude all of the virtual currencies that currently exist. But it would accommodate a central bank digital currency that could be issued in the future. Now, that doesn't mean that Bitcoin and Ethereum and the like have no place in the 2022 amendments. They're still controllable electronic records. And you still get the virtues of the adverse claim cutoff rules in Article 12, so that you can still treat virtual currency as negotiable like you would money.
Wow. Fascinating stuff. So are there other types of changes in the the 2022 amendments that we should be aware of?
Yes. Remember, the amendments deal with the entire Uniform Commercial Code, not just with digital assets. So we do have a definition or some changes to the definition of chattel paper. We do that by recognizing the fact that hybrid chattel paper is very common. This is where it's part in tangible form and part in electronic form. So we really get rid of the definitions of tangible chattel paper and electronic chattel paper, just refer to chattel paper, and refer to the chattel paper as the right to payment that's evidenced by the record, in order to be consistent with what we've done in Article 12, where we distinguish the record from the right to payment, the controllable payment intangible, the controllable account. And then we have a method for control for electronic chattel paper that is very similar to what you see for control for controllable electronic records. We keep the existing safe harbor that you have in the definition of control for chattel paper in electronic form. But we also add a new safe harbor that permits really distributed ledger technology to work for chattel paper in electronic form, where you can have the existing safe harbor refers to a single authoritative copy. With distributed ledger technology, every copy is an authoritative copy. So as long as you have control over all of the authoritative copies, in other words, only you can change the record, basically, that you're generally in control of that as well, and you're not inhibited by the single authoritative copy definition. And by the way, we do have a definition of control for electronic money that also tracks what we're doing with controllable electronic records and chattel paper in electronic form. So if we do have in the future a central bank digital currency, and it's not held through a normal bank account where the normal deposit account rules apply, there is a way of perfecting a security interest in electronic money that's account-based rather than deposit-based. And then for negotiable instruments, we added provisions saying that if you have a negotiable instrument that states a governing law clause or a choice of forum clause, that neither of those clauses destroyed negotiability. Now, why is that important for electronic transactions? If we look at transferable records under UITA and e-sign, to have a transferable record, you need to have a record that, if it were in writing, would constitute a negotiable instrument under Article 3 of the UCC. So now you can put into your transferable record, a choice of law and a choice of forum clause that sends you to a state that has adopted UITA. So if you have a dispute over a transferable record that arises in a foreign country, it's more likely that the country will respect the transferable record either through the choice of forum clause or through the choice of law clause. So I think that's helpful for those who deal in transferable records in existing marketplaces. And then there are a bunch of miscellaneous amendments that we made to the UCC. One is the UCC has a whole number of writing requirements. Now, those are not overridden by UITA and e-sign, because UITA and e-sign overrode writing requirements only for Article 2 and Article 2A. So we made it clear that we changed everything in the UCC that had referred to writing to record to pick up electronic commerce. Now, we didn't do that for Article 3. You still need to have an instrument in writing to have an Article 3 negotiable instrument, and you need to have an instrument in writing to have an Article 9 negotiable, Article 9 instrument. But otherwise, we made these changes so that pretty much every writing requirement has now become a record requirement. And then similarly, in the definition of signed, we made it clear that you can have an electronic signature. And one of the virtues of that is that we can get rid of this awkward definition in Article 9 of authentication. Remember, we have this definition of authentication that was to make clear that you can have a electronic security agreement that is electronically signed. But now that we've changed the definition of signed to include an electronic signature and referred to an agreement as being a record rather than a writing, just exclusively a writing, then you end up with the fact that we can get rid of authentication, and now we can have the more natural flow of a security agreement signed by the debtor that would pick up electronic commerce. We also played a little bit with the definition of conspicuous in Article 1. That's relevant largely in disclaimers of warranties under Article 2 and Article 2A. There were examples of conspicuous disclosures in the definition that referred to capital letters, different colors. And there is a real question as to whether those even worked for paper transactions, even let alone electronic transactions. So we took out those examples, made it clear that it was the totality of the circumstances that determine whether a statement is conspicuous. And then the official comments, which are quite extensive with the 2022 amendments, give a really good roadmap over how you can make sure that a statement is conspicuous, even in the electronic commerce environment. We played with the definition of person to make it clear that a protected series of a series organization is treated for UCC purposes as a separate person. For those of you who don't know, a series is typically found in limited liability companies, but it could be other organizations. that have different cells, and each cell has its own assets and liabilities, and one cell is not responsible for the assets and liabilities of another cell or the mothership. And if you're dealing with a series, what we call a protected series in that situation, you can treat that as a separate person. There has been a concern in large transactions that involve the sale or lease of goods, the provision of services or other property, that it's unclear whether Article 2 or Article 2A applies to the transaction because of the mixed nature of the transaction. And so we provide some guidance in the official text that tell us that if the predominant purpose of the transaction is to acquire the goods, then you're in Article 2 or 2A. If that's not the predominant purpose, then if the claim relates to one relating to the goods, then you're in Article 2 or 2A, but not the entire transaction. We added a definition of control for electronic documents in Article 7. And then that was really very consistent with the definition that we have for control of chattel paper in electronic form. We also added a clarification in Article 5 that responds to a particular court decision that held that if you have a choice of law clause in a letter of credit, that a branch of a bank is no longer considered to be a separate entity, which resulted in a very bizarre outcome of this one case. We've now made it clear in Article 5 that just because you have a choice of law clause in the letter of credit, you still treat a separate office of the bank as a separate entity. And we added a expanded definition of assignor and assignee in Article 9. There have been cases that look at Part 4 of Article 9 and the term assignment and assignor and assignee and say, oh, what must have been meant here is a true sale. And other courts have said, no, what must have been meant here is a security interest that secures an obligation. So we have some very strange cases out there that say that factors, for example, do or do not get the benefit of the Part 4 rules of Article 9, when we all intended that assignment was to pick up either a true sale or an security interest that secures an obligation. That's stated in the official comments. There's a PEB commentary that emphasizes that, but courts were still confused, so we now elevated the comment to the statutory text. And then finally, we added some provisions to make clear that even though to take a security interest in a commercial tort claim as original collateral, you need to have a more specific collateral description. That's not the case when the commercial tort claim is proceeds of other collateral. Now, the policy reason for that is that the reason for a more specific description is to show that the commercial tort claim was reliance collateral, that it's not just something that the secured party picked up as a bonus. But if you have collateral for which the where the proceeds are commercial tort claim, there's no reliance. In other words, if I have a security interest in a machine and the machine gets damaged by an arsonist, so the debtor now has a claim against the arsonist, there's no reason for the secured party to have to go amend its security agreement to pick up this claim against the arsonist. The claim against the arsonist is supposed to be a substitution for the loss in value of the collateral. So we made that clear as well. And then we do have transition rules. There's no uniform effective date. We thought that that was not going to be something that would be possible, given the fact that so many states want to show their leadership in this area, and therefore have even enacted, in some cases, prior drafts of what we have done so far. So each state is on its own in determining the effective date for these 22 amendments. But there was one area where we thought that we should provide some sort of delayed effective date, and that is where you have a reversal of priorities under the amendments from what you had under prior law. So let me give you a very quick example. Suppose SP1 perfects a security interest in a controllable electronic record before the effective date. SP2 obtains the control of the controllable electronic record. Well, control of the controllable electronic record means nothing under current law. That's not a method of perfection. But once the amendments take place, then a control interest beats a filed interest, and SP2, even though later in time jumps ahead of SP1. We thought that there should be a delayed effectiveness for that change of priority, not for perfection, but for priority. And so there is a delayed effective date of at least 1 year called the adjustment date. That delays the effectiveness of the reversal of those priorities. During that time, SP1 can do whatever it needs to do to protect itself, or push the debtor into a refinancing, call a default based on the further assurances clause, negotiate with SP2. There are probably a number of possibilities. So that's a quick tour of some of the other issues, Don.
Well, thank you, Ed, for your efforts in these 3 interviews. You know, this has been fascinating and most helpful for most of us. I believe all the electronic commerce details are a bad combination of unfamiliarity and complexity. And so your efforts here to bring some familiarity and get rid of some of the complexity is greatly appreciated. Thank you.
Well, it's my pleasure. And I'll just mention that for those of you who would like to see the amendments and the official comments, they are up on the Uniform Law Commission website, as well as some summaries of the provisions. So if you're a little bit deterred by the 185 pages of text and comments, and you want to get the Cliff Notes version, we have those up too.
Well, thank you very much, and we'll conclude this and just say thanks for your efforts here.
Okay, my pleasure.